Good morning, everyone. It's 10 a.m. and I'd like to welcome everyone to the Tennessee Department of Commerce and Insurance to the August 9th, 2022 meeting. Ms. Bohannon, if you'd call the roll.
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Haynes.
Here.
Chris Lee.
Here.
Scotty Porsche.
Here.
Charles Rahm.
Here.
Pam Stevens.
Here.
Mr. President, all members are here and counted for.
Thank you, Ms. Bohannon. The chair will entertain a motion for adoption of the agenda.
So move.
I have a motion by Mr. Harris, a second by Mr. Berry. All in favor?
Aye.
Next item is the minutes that you all have received from the June 14th meeting. If you haven't had a chance to review those, I have a motion by Mr. Berry, a second by Ms. Stevens to approve the minutes from the June 14th meeting. All in favor?
Aye.
Next on the agenda is the legal report. Mr. Bryant, the Associate General Counsel.
Mr. President, I need to recuse myself, please. As well.
Let the record reflect that Mr. Harris and Mr. Berry both will be recusing themselves and stepping out of the room. All right, Mr. Bryant, I believe we can proceed.
All right. Complaint number 1 is complaint number 2022-017301. Complainant, licensed embalmer, filed a complaint alleging that while in the process of renewing their embalmer's license, they saw an unfamiliar apprentice registration that they did not give permission for. Respondent replied stating that they had spoken with complainant who informed them that the allegations in the complaint were a mistake. Respondent explained that complainant had accidentally read respondent's middle name as their first name and did not recognize the name. Respondent stated that complainant had sponsored their apprenticeship and had informed them that complainant would reach out to cancel their complaint. The complainant did email the department stating that they had recently submitted a complaint and asked that the complaint be withdrawn, admitting that the allegations had been an oversight. Therefore, we would recommend closure.
Questions? Chair opens the floor for a motion.
Second.
I have a motion by Ms. Stevens, a second by Mr. Lee. All in favor?
Aye.
Second complaint is complaint number 2022-021071. Complainant alleged that respondent establishment had committed willful noncompliance with the consent order previously entered by respondent establishment in 2014. Specifically, complainant stated in that previous consent order, respondent had operated and conducted their business under an illegal name. Complainant alleges that this has still continued up and until May 21st, 2022. Respondent replied, agreeing that a consent order had been entered by the establishment in 2014 regarding the business name of the establishment. Respondent added that since that time, the legal name of the business is the current name of the establishment, and they have been in compliance since the consent order was signed. After consulting core, legal determined that the current name of the establishment is the name which the department has on file for the establishment. Therefore, we would recommend closure, with any other remaining issues to be determined by a court of competent jurisdiction.
Questions or concerns?
Second.
I have a motion by Mr. Lee, a second by Mr. Porch. All in favor?
Aye.
Complaint number 3, complaint number 2022-022311. Complainant, son of the deceased, filed a complaint against respondent funeral establishment alleging unprofessional conduct. Specifically, complainant stated that the caregiver and power of attorney of the deceased selected respondent's funeral services against complainant's wishes. complainant asked that respondent release the remains of their father to a different establishment. Respondent replied, stating that the caregiver, who also had power of attorney, contacted the establishment on May 20th, 2022 to make arrangements for the deceased. Respondent stated that during this conversation, the caregiver informed respondent that she had the power of attorney and that she was in possession of the deceased's will. Respondent also stated that they were informed by the caregiver that there was friction among family members regarding the arrangement of the deceased. In their first meeting with the caregiver, the respondent stated that the caregiver provided papers for a general and durable power of attorney, a will that gave the caregiver all powers, and paperwork from the hospital that had her name on it. The department received an email from the caregiver and power of attorney who requested that the complaint be dismissed and that respondent was not liable for any wrongdoing. Additionally, the department also received an email from another son and daughter-in-law of the deceased, who confirmed that they were aware that the caregiver had a durable and general power of attorney. Based on the above, the heart of the matter is a next of kin and power of attorney determination. Therefore, we would recommend closure with any lingering next of kin determinations to be made by a court of competent jurisdiction.
Questions for Mr. Bryant? Chair will entertain.
Make a motion to accept council's recommendation.
I have a motion by Mr. Lee, a second by Mrs. Stevens. All in favor?
Aye.
Motion passes.
Complaint number 4, complaint number 2022023571. Complainant alleged that respondent had given out personal information to complainant's father and his girlfriend. The information was alleged to include complainant's social security number, address, email address, and wife's number. Complainant stated that they believed this to be a HIPAA violation and a violation of their privacy, alleging that the information was now in the hands of people they were concerned would use it to seal their identity and take out credit cards or loans in their name. Respondent replied, stating that on January 24th, 2022, after complainant's mother had passed away, complainant approached respondent to request a funded pre-need for complainant's father as his power of attorney. Respondent stated that on May 5th, 2022, the father of complainant came to the establishment unannounced and asked for a copy of his pre-arrangement paperwork. Soon after this occurred, the respondent stated they received a call from the insured's daughter-in-law expressing concern that the father may try to cancel and cash out the policy. The respondent explained that the policy can be made irrevocable with simple paperwork, and in 30 minutes the complainant and the daughter-in-law arrived to change the policy to irrevocable. After the paperwork was prepared, it was signed and then faxed. Respondent stated they received no additional communication from complainant until this complaint. Respondent stated that at no time did complainant ever indicate that they had concerns that the father would try to cancel the policy or that they should not provide information to the father. Respondent stated that they provided a copy of the pre-arrangement paperwork to the insured and that who he shared it with afterwards was not within their control. Based on the above, we would recommend a letter of warning. If I can be candid, I very much struggled on this, whether a letter of warning or just closure was appropriate. Essentially, it's, while I understand the difficulty of the situation and they provided the paperwork to the insured, that release of information I understand is very sensitive to the complainant. However, this is something that I would certainly defer to the board members who know the business and whether that is essentially that information is just on the document or not. So to answer your question more directly, the letter of warning is, so I understand the sensitive nature of the information, though I do also recognize that it put the respondent in a very difficult situation.
Microphone no.
1, 2. Okay. Is that better now, Miss Lynn? Maybe I need to pull it to me. Personal. I had to hold it. Thank you, dear. I'm gonna get it. maybe redact the personal information like social security number, phone number, whatever of the policy holder when the insured picked it up, I guess would have satisfied everybody down the road.
That certainly could have been an option they had, but also recognizing the situation of the respondent of if we take their word on this, which we have no reason not to.
Exactly.
They did not even know that was a concern of the complainant. Again, I would certainly defer to the board's thoughts on this one. Again, kind of the letter of warning was more of just a consideration of I understand the difficult situation, but also understand complainant's reservations with the situation.
And I'm confused on this. Isn't that person entitled to their own information? And if they did black it out, he's got it anyway.
So, from my understanding, the complainant, who is the son of the insured, it was his information that was made available to the insured. So, when the father came in for his policy, that information of his son was on the document. And that's what the son is concerned about now, that his information is in his father and potentially somebody else's hands as well.
Was it on there as the beneficiary of the policy, or?
Yes.
Okay.
That is correct.
Ms. Pam, if that was a form of motion for closure instead of letter of warning, I don't want to step ahead of you, but
I'll go with legal's opinion as my motion. So the motion is to go with your opinion for letter of warning.
I have a motion by Ms. Stevens, a second by Ms. Haynes to accept recommendation. All in favor?
Aye.
Motion passes.
Next complaint is complaint number 2022-025011. Complainant alleged that the respondent establishment had picked up and embalmed the deceased remains without her knowledge or consent. Respondent's counsel replied stating that complainant had filed a companion complaint in Florida and that the funeral home in Florida is owned by the same corporate entity as the Tennessee respondent. Respondent stated that on February 26, 2022, the Florida establishment received a call from a caller representing that she was the sister-in-law calling on behalf of complainant. The caller inquired as to how to have a decedent transferred to Florida from Tennessee, to which the respondent explained that the remains would be retrieved and embalmed by the respondent establishment and then shipped to Florida. The caller stated that she was there with the wife, who then asked permission for those arrangements to be made. Respondent stated that the wife gave approval for the Tennessee/respondent establishment to pick up the deceased from the medical examiner's office and began embalming to be shipped to Florida. Following this discussion, the father of the complainant also called the Florida establishment to make further arrangements. Florida establishment set up a conference to discuss further arrangements. However, 20 minutes before that conference, the Florida establishment was informed that complainant had selected another funeral home. This was then relayed to the respondent/Tennessee establishment, who soon after shipped the remains to the new funeral home. Respondent Tennessee establishment provided a decedent release request form which noted they had received verbal approval by phone and provided recorded phone calls which corroborated respondent's version of events. Legal spoke to an investigator for the Department of Financial Services Division of Funerals, Cemetery and Consumer Services in Florida, who had investigated the Florida complaint. The Florida investigator made findings virtually identical to that of respondent's recollection of events. The Florida investigator found no violations on part of the funeral establishment. During conversations with legal, the investigator provided that he believed, since the sister-in-law of the complainant and the father of the complainant had handled all the arrangements on complainant's behalf, due to the stress and traumatic matters at hand, complainant had forgotten that initial arrangements had been made with the Florida and Tennessee respondent establishments. Based on the above, we would recommend closure.
Questions for Mr. Bryant? Chair will entertain
Motion to accept council's recommendation, closure.
Second.
I have a motion by Mr. Lee, a second by Mr. Porch to accept the recommendation. All in favor?
Aye.
Motion passes.
Next complaint is complaint number 2022-030611. This complaint was administratively opened following the submission of photographs taken on July 24th, 2022, that demonstrated that the establishment was holding itself out to the public as a licensed funeral establishment. Specifically, these photographs show that the proposed establishment name was prominently displayed on the outside of the building, had the business hours of operation and the phone number on the front door, along with phrases advertising the proposed establishment name, along with, quote, available 24 hours. Respondent replied stating that they agreed that the signs and information were not covered and acknowledged that the signage should have been covered immediately after installation while waiting for board approval. Respondent attached photographs to show that the sign on the front of the building and the information on the door had been covered. The department sent this case for investigation. First, the investigator visited a local funeral home who would handle the storage of the deceased for respondent, and a cremation company to determine whether respondent establishment had conducted any business prior to proper licensure. The investigator determined that both locations anticipated doing business with respondent establishment in the near future, but that neither location had done business with respondent at that time. Next, the investigator traveled to the respondent establishment and met with the licensed funeral director and embalmer employed as the manager. The manager stated that after the initial inspection on July 19, 2022, on July 22, 2022, the signage on the building was erected along with the information on the door. The manager stated that the signage for both the building and the door were supposed to be covered, however, neither was covered at the time of completion. The manager stated that upon receiving the complaint, both signs were immediately covered on July 25, 2022 at approximately 9:44 a.m. and have remained covered until the date of the inspection. The manager stated that though the office phones were operational, the telephone line had been forwarded to another establishment location, and that the phone number for the respondent establishment had not been printed or given to the general public except for the time that it was posted on the door. The manager stated that no business had been conducted by any staff member to present date, further stating that the only people who had entered the building were construction workers, tech persons, and persons making deliveries of supplies. The investigator concluded the report by stating that they found no evidence of the establishment's name listed on any documents at the other investigative funeral home, the cremation company, or the respondent establishment. Although the cremation company had created a file for the respondent establishment in anticipation of their pending licensure, the file contained 0 cases. The investigator found no evidence that the respondent establishment had conducted any cremation and or pre-need services to the present date. After researching the internet, the investigator discovered that though the corporate conglomerate had listed the new location on their website, unlike the other licensed locations, this location did not contain a live or active link and cannot be clicked on by potential consumers. Based on the above, it appearing that respondent conducted no additional unlicensed activity other than holding out to the general public that they were a licensed funeral establishment via the signage and door information, we would recommend a $250 civil penalty plus the cost of investigation, authorizing via consent order and formal hearing if necessary.
Questions for Mr. Bryant?
Question. So, in other words, the $250 civil penalty is based on that time frame of July 19th to 22, where the signage was on the building in not appropriately for the timing.
That is correct, yes.
Chair will entertain a motion.
Move for approval.
I'll second.
I have an approval by a motion by Mrs. Stevens, a second by Mr. Lee. All in favor of the recommendation?
Aye.
Motion passes.
The final one is a represent, complaint number 2022012801. The summary at that original board meeting was that complainant, sister of the deceased, stated that her sister passed away on November 4th, 2016, and that respondent was responsible for the final care. Complainant stated that respondent dealt directly with her mother regarding the cost of the service, and that for reasons unbeknownst to her, respondent was not paid for the entire cost of the services. Complainant alleged the respondent had sent the family pictures of the, quote, naked cancer-ridden body, and, quote, of the deceased, stating that, quote, this is what he had to work with, while requesting complete payment. Respondent replied stating that back in October of 2016, arrangements for the deceased were done over the phone, and the payment policy was explained. Respondent stated that prior to the service day, the establishment had advanced upfront a charge of $8,495.96, despite the fact that the family had yet to pay any of the services costs. Respondent stated that despite this, the service proceeded. Respondent further stated that the deceased had had a life insurance policy, but that the beneficiaries, the mother of the deceased, and the daughter of the deceased, had not tendered any money for payment. Respondent maintained that he did show a facial picture of the deceased to the cousin of the deceased, who is a friend of the respondent's, and the cousin's sister to show the condition in which he had received the deceased and the work that had been done to, quote, make her look presentable for the family. Respondent stated that the total funeral and burial services provided were $18,063.96, and that to date he had only received $6,232.78 of payment. Respondent added that the family had recently received a bill for the remaining balance, which provided the motivation to file the complaint. Respondent contacted legal with additional information related to this complaint. First, respondent apologized, stating that his original response was not clear as to the events of this complaint and provided a more thorough accounting. Respondent stated that the deceased lived in California, but had in her will to be transported to and buried in Tennessee. The deceased cousin contacted respondent on behalf of the family to provide service. Respondent stated that he personally paid for the body to be embalmed and air transported to Tennessee and advanced funds to purchase the casket and burial plot. Upon receiving the body of the deceased, respondent was shocked at the condition, especially considering that the family had insisted on having an open casket funeral. Respondent stated that he showed a facial photograph only of the deceased to demonstrate his concerns over whether adequate restoration could be done to the body to allow an open casket viewing. Respondent vehemently denies ever sending a naked picture of the deceased to anyone at any time. Likewise, respondent stated that the only picture that was ever shown was the facial picture shown to the deceased cousin 5 years ago. In support of their position, respondent provided an affidavit of the deceased cousin, who not only corroborated that he had received only a facial photograph of the deceased, but praised the job at which the respondent had done, allowing the family to have an open casket visitation. The deceased cousin added that he was in no way offended and stated that respondent was totally professional as his handling of the deceased funeral. Finally, the deceased cousins provided that at no time prior to the filing of the complaint had complainant ever expressed dissatisfaction with the respondent until a collection agency contacted the family for past due payment. On August 3rd, legal spoke to both complainant and the affiant. First, during the conversation with complainant again alleged that the family had received a, quote, naked picture of the deceased. However, legal required as to whether complainant had seen the pictures themselves, and she admitted that she had not. Complainant stated that the sister of the affiant had told her she had seen a picture of the deceased, and it caused her to be upset. Again, complainant stated she had only heard about the pictures through a family member and had not seen them herself. Additionally, contrary to what had been implied in the initial complaint, complainant stated that the pictures in question were not recently received by the family along with the bill, but were instead seen, quote, several years ago. Finally, legal spoke to the deceased cousin/affiant, who had also been in charge of making arrangements for the deceased on the family's behalf. This individual largely reiterated what had been stated in his affidavit, adding that the respondent had done a fantastic job and that the complaint was only sparked when the complainant received a letter from a collections agency requesting payment. The individual further added that to his recollection, he could not even recall if his sister, whom the complainant relied on for information, was even present when respondent showed him the photograph. The deceased cousin concluded that respondent had done the family a massive favor by flying the deceased from California and providing services so that an open casket funeral could be possible. Based on the above, after examining the additional information provided by respondent, the affiant, and the complainant, not only has respondent provided evidence to conflict with the second-hand accounting of the allegations, but the complaint is not based upon first-hand knowledge. Therefore, we would make a recommendation for a letter of warning.
Question. Basis for the letter of warning is what?
So essentially in that, this is another gap in my knowledge of the funeral business, but Although I was very pleased to hear from the affiant that he was not offended by the picture, I understand how that may be risky to show a family member. Again, very happy that it seems that it turned out, kind of ideally, but just kind of maybe a letter of warning to say that perhaps in the future, to avoid instances like this where a family member might see that and become offended, to perhaps avoid that in the future.
That's a lot of information to no fault of yours that I wish the respondent had provided when we initially met on this case. And it's so easy to file a complaint and for all of this to come up 6 years after a funeral. And I thought I'd read initially where maybe the cousin actually worked for the respondent.
No.
Okay.
The cousin and the respondent were friends.
Okay.
But did not have a business relationship.
It's just kind of funny to me that all this came up after they were trying to collect the debt, and then secondhand information. That really bothers me. I'm making a recommendation that is closure.
Form of a motion.
Form of motion.
I have a motion by Mr. Lee to change the recommendation from letter of warning to closure.
I'll second.
I have a second by Mr. Porch. All in favor?
Aye.
Aye.
Any opposed? Motion passes.
And that concludes.
Thank you, Mr. Brown. All right, next item on our agenda is the Executive Director's Report. Mr. Robert Gribble.
I think legal has one other matter, Mr. President.
Oh, I'm sorry.
Very briefly, board members, I just wanted to provide an update on the pending rules from the rulemaking hearing a few board meetings ago. Currently, those are with the governor's office undergoing review. My understanding of that is they are about wrapped up with that, so it'll be moving to the next stage, which will be the rules will be sent to the Attorney General's office, or they will also take them under review. Then those rules will be filed with the Secretary of State's office, and then finally it will go to GovOps, where they will conduct a review of them. But I just wanted to provide an update in case anyone had any questions about where those were and in the process of becoming active.
Thank you, sir, and my apologies for overlooking that on the agenda. Now we'll turn to Mr. Gribble.
Thank you, Mr. President. Good morning, board members. I know I sent you an email back in June about this, but to remind everyone and then answer any questions you might have, is that the International Conference of Funeral Service Examining Board is moving the exam program from a state board exam / national board exam to a National Board Arts and the National Board Exam Sciences, and that'll be effective 2023. I guess I'll read just a paragraph here for the benefit of those that might be listening or listen to the meeting later. The International Conference of Funeral Service Examining Boards is pleased to share its strategic initiative that will streamline its examination program. The Board of Directors is ever mindful of the need to review programs and policies to help make the examinations role in the licensure process as efficient as possible for those who can demonstrate the minimum competency skills required to safely serve the public. In that spirit, the conference will consolidate the state board exam, SBE program, and the national board exam, NBE program, beginning January 1, 2023. All candidates for licensure will take the NBE Arts and or the NBE Sciences based on eligibility requirements set forth by their regulatory board / agency or their ABFSC accredited program. That's American Board of Funeral Service Education. And then it goes on to talk about it in more detail, and then there's a FAQ on the conference website. A couple of things. Complete transparency. I am a current board member of the International Conference Funeral Service Examining Boards, and I don't make any decisions based on her board while I'm serving on that board. I want to make that clear and transparent. And of course, Mr. Spann, Steve Spann, who's president of John A. Gupton College, who's in the audience today, is familiar with this, as well as I think Mr. Batson, Bob Batson, with the Tennessee Funeral Director Association, has either been contacted or will be contacted soon about it. But basically what it will do, it's basically been pretty much the same, the questions have come from the same test bank for years. So it gives more credibility to those who are taking the exam to be able to go to other states and apply for reciprocity. And it eliminates the confusion. It does create, Mr. Spann and I have talked, there's a possible scenario or two that's come up maybe once or twice in the last 5 years that this may create a problem for. I'll continue to talk with him, and I'm sure he'll continue to talk with Daylene Paul, who's the Executive Director for the International Conference of Funeral Service Examining Boards, to address any concerns or issues he has. But I want to bring it up to the board and remind everyone of what's transitioning on January the 1st, and see if you have questions, or if, with the President's permission, if Mr. Spann or Mr. Batson, either one would like to speak, they may want to speak to it as well.
Absolutely. Mr. Spann, Mr. Batson, either one of you would like to comment?
Only slightly. It fixes a problem for me and causes a problem for me. Occasionally, and Robert and I have talked, I've probably had 5 in the last 10 years of someone that goes through comps and can't pass comps. And they can't pass comps, and they can't pass comps. And they finally decide, I'm not going to take it again. And we'll say, hey, well, why don't you go take state board? Because I'm not going to reduce my standards and send you to the national board exam. So I'll reduce my standards, let them go take the state board, and I've had 1 of the 5 pass. That won't be an option in the future. Okay, so that's a very minor problem. Like I said, maybe 4 or 5 times in the last 10 years. Something that's going to get more prevalent is I've got people taking the funeral director only program, which is not accredited, which doesn't count against me if they fail it. So now they go take this exam, and it's considered the national board exam. Still doesn't count against me if they fail it. And then they'll come back later on and say, hey, I want to do the embalmer program now. Well, in the past, that's been a problem because for accreditation, if you take the embalmer, you got to go take the state again or the art side again. Now they won't have to because they've already passed the arts. Does that make sense? And then they just have to take the embalmer side. So actually, in the future, it probably will help me more than it hurts me. But those few occasions, it's a little bit bad. But anyway, I have no real problem with it. We'll work around it. Thanks.
Batson, you have anything to add? Ditto.
Any board members have any questions about that? I will, while we're on the subject, it's a little bit different, but mention this. Some states are going and developing their own tests, and I would not want to be responsible for that because the exams need to be legally defensible, and there needs to be a minimum standard of competency. And some states are lowering their scores, and the conference is in the process of determining what the score should be. This will come later as well, and Mr. Spann, I think, has volunteered to serve on that committee for the conference if he's selected by the conference to do that. But it's regulatory agencies realize that everybody needs employees. Everybody needs a licensed funeral director, and everybody needs a licensed embalmer. And I guess the question becomes, do you want to change the standards? And by changing the standard, are you going to lower the standards? We have a state that's adjacent to us. Recently did their own exam, lowered the score to 70. Of course, the passing score in Tennessee is 75 on the arts, 75 on the science, and 75 on Tennessee law, rules, and regulations. And when I've had some long conversations with their executive director, and I said, what's going to happen when these people get their license in Alabama, and then they're for some reason they decide to move to another state that has different requirements. And he said, we have them to sign, that we give them a disclosure and have them to sign saying that other states may not accept this license because it's a license developed by the board, administered by the board, and that's all well and good. But 5 years later, when I've moved to some other state, and then this is my whole livelihood, and I can't get a license somewhere else, or may not can get a license somewhere else, then yes, I'm going to remember that I signed a document 5 years ago, but I'm still going to be upset and mad that the other state may not. And so I don't know. I don't know how all this will, fall out in the end. I understand that maybe states are looking at doing the same. And in transparency, there are people that are upset about the national board exam because they think it's too hard. They think that it's, that the questions are too hard. And it's, all that's being reviewed and talked about and discussed. And some people are very adamant about that. But to make you aware of this and answer any questions you have, and be glad to keep you updated if you have other questions.
Mr. Gribble, I have a question. Thank goodness I didn't have to ask this question when I took my test, but is there a number of times that someone can or not pass the test? Is there a maximum number, or can a student continue taking the test until they actually pass it?
Only take it once every 30 days, but if they want to sign up for it, pay the fee, and take it, they can. At one time, there was a limit of, I think it was, Mr. Spann probably knows this better than me, but I think it was 3 times during one calendar year. But I don't know what you remember. But that has been removed. And we get a report, Ms. Bohannon and I and Tammy Hart's administrative assistant for the funeral board. We get, as soon as the people test, we get a electronic report and verification of what their testing scores were, and we usually get that within two to 3 days after they take the test. And I look at every one of them. When the email comes in, I open it, I look at it. And we've got more than one individual that's probably taken that test 8, 9, 10, 12 times. Now, there's nothing in the Tennessee law that prohibits them from doing that, and there's nothing that prohibits the board from issuing them a license if they ever pass it. And this is just my opinion, and I don't have it backed up by any facts, but from what I see as far as the Tennessee people, if you've got a candidate that's making 72, 73 on the test, they can probably study, maybe get tutored, and they'll eventually pass that test. Maybe it might take them another time or two. If you got somebody making 56 or 60 or 65, they probably need to think about doing something else. That's, but some trying to.
Thank you.
And I'll make one other comment about that. The testing agency contracts with Pearson View for the test to be administered at Pearson View location. And there's a lot of security that goes in to make sure that the right person shows up, that they don't have electronic things in their sleeves or in their ears or on their body, or they're not pulling out notes, or they're not going to, So there's a lot of safety precautions that goes into that to ensure that the test is taken to the proper person in the proper way. Is it perfect? No, it's probably not perfect, but it's pretty close. It's pretty close. And I made mention of this. Mr. Spann had volunteered to do this. It's called the Standard Setting Committee, which will meet later this fall. And it's really the people who will determine the passing score for the exam. And I forwarded that email to each of you as well. It needs to be someone who has passed the arts and science sections of the National Board exam, currently licensed and practicing as a funeral director and embalmer with a license in good standing. And of course, each of you except the public member would have licenses, but you would need to also be licensed in both areas. But if you're interested in doing that, I would encourage you to, to fill out the form, volunteer. Obviously, 6 or 7 people in Tennessee won't be selected, but hopefully 1 or 2 would be selected. Because it's very important, because what happens is that committee sets the raw score. Even though 75 is passing, the raw score is set a little bit, because that's a scale score, and the raw score is set a little bit below that. So it appears to me that the advantages are there for the applicants and the ones who are seeking licensure, that it's a fair playing field, and I think it's important to ensure that over a longer period of time. Next item is a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of June 13, 2022 through August 5, 2022. You'll see those listed there in front of you. Establishments and the funeral directors and embalmers. We have several people who we license through. Have a number of people that either close by in Tennessee and wanting a license to practice in Tennessee, or move here and wish to practice here. There's one establishment that's reported closing since the last board meeting. That's Costner Malloy Funeral Home at 322 East Main Street in Newport, Tennessee. Disciplinary action report is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority, and as reported on the May 2022 and June 2022 Regulatory Board disciplinary action reports. And those are there for you to see as well. Lastly, for my report is a complaint report for this meeting. As far as funeral director and embalmer complaints, we have 14. Establishment complaints, we have 12, for a total of 26 complaints. That concludes my report, and I'm glad to answer any questions.
Any questions for Mr. Gribble? If not, the chair will entertain a motion.
So move.
Have a motion by Mr. Harris, a second by Mr. Berry to approve the Executive Director's report. All in favor? Aye. Next item on the agenda is application for licensure. We do not have any individuals today, but we do have one establishment.
President, I need to recuse myself, please.
Well, the 2 bad boys have got to be excused again. We appreciate y'all's attendance today.
President, I'm unsure. I don't think anyone is physically present to represent this establishment, and I've been in consultation with Ms. Bohannon, and it doesn't appear that there's anyone online. You think so? Ms. Bohannon tells me that the proposed manager for the establishment was there, and she's off. So I'll kind of set it up, and then you might ask if there's someone online, we can actually bring them into the meeting where you can ask them questions. This establishment application is for Neptune Society. Tracy Mays Gooding Summers is the proposed establishment manager. Establishments to be located at 10669 Harding Valley Road in Knoxville, Tennessee. It's a new establishment. It's an ownership as a corporation, and it's owned by Neptune Management Corporation, 100 Northwest 70th Avenue, Suite 200, Plantation, Florida, 33317-2901. Board members, we would ask you to consider this application for approval today with some caveats. One is they need to correct their information on their general price list, casket price list, outer burial container price list, and statement of funeral goods and services selected. And that's probably a typographical error or a misunderstanding concerning their zip code. We also need a letter. Statute is clear that we need a letter, even though they may not offer embalming. They need to have an establishment that will provide embalming should they decide to offer that, or should they offer that. Their parking compliance letter mainly tells us how many parking spots are required, but it doesn't say whether or not that their parking requirements are in compliance, which it appears that they are, but still we would like for the letter to so state that instead of stating how many are there. There's also another matter that needs to be resolved, and so with those caveats, we would ask for you to consider it for approval, review it for consideration of approval, and basically ask that you leave, if you decide to approve it, that you leave a determination to me as the executive director along with legal counsel in determining when a license would actually be issued to this establishment if the board approves it today. We had some deliberations about whether we should put this application on the agenda today, and we felt like we should because the next meeting won't be until September, so it would be, some period of time, more than 30 days, because I think it's September the 13th, if I recall correctly, before that their application could be considered. But again, as Mr. Bryant so eloquently says, all those decisions are up to the board, and whatever you decide, we'll be glad to move forward from there. But again, we don't know if someone's on the line or not. No one appears to be a representative of the firm.
Mr. Gribble, I'm assuming with your presentation, you and legal counsel are good with the board approving this with those stipulations? You all have no reservations?
That is correct. So long as those caveats are kind of carved in, then we would have no issue with them.
Are there any questions from the board?
I have a question. On the application, isn't it pretty clear that naming a service for embalming be on there? Or is that not clear for the application?
Yes, it is. My understanding is they don't intend to offer that service, so the funeral rule might not require that to be listed as one of their services they offer, but yet we have a Tennessee statute that requires that all establishments have an embalming facility available to them.
So it may have been not an oversight. It may have been that they didn't think that they had to have one. Okay.
We have outlined to them our concerns in an email, and only did that Saturday, because again we were still deliberating as to whether or not we should bring this application before you. And we told them that they didn't have to have all those things addressed by today, because that's, it's hard to go back to the zoning agency and get a letter in one day. We realize that as well. Most likely it's hard.
If there are no other questions, the chair will accept a recommendation.
President, I'll offer that in form of a motion that we approve the licensure based on Mr. Gribble and legal making sure everything is up to code, I guess, and where it needs to be. I trust those two more than us, so.
I have a motion by Mr. Lee.
A second.
I have a second by Ms. Haynes. All in favor?
Aye.
Any opposed? Motion carries. Next item is new business. Is there any new business to come before the board? If not, I'll entertain a motion for adjournment.
So move.
I have a motion by Mr. Harris,
Let me say.
a second by Mr. Berry. All in favor?
Aye.
Meeting's adjourned. Yeah, we